Welcome back. 7:43 the time. The man accused of shooting and killing conservative activist Charlie Kirk is facing 7 total charges, including aggravated murder. Appearing remotely, 22-year-old Tyler Robinson sat through his first court hearing held in a Utah courtroom yesterday. He wore suicide prevention smock while attending the hearing from jail, not saying anything other than his name for the record. Robinson's aggravated murder charge would tie the crime to Charlie Kirk's political beliefs. Prosecutors are seeking the death penalty. The hearing came after the state listed its mounting evidence, including DNA found on different parts of a rifle. Prosecutors say the suspect's parents recognized him from campus surveillance footage released to the media and convinced Robinson to turn himself in. Robinson is also accused of sending messages to his roommate explaining his plans to kill Kirk. We want to bring in our chief legal analyst, Connolly Feroz, to talk about where this case stands right now. We played the audio of them reading the text message exchange here. I want to start there with the text messages. Is that enough to start building, okay, this is intent?
Well, there's text messages all over the place. There's text messages between him and his parents. There's text messages between him and his roommate. And so I think both of them will paint the picture that this individual, as they listed when I listened to the interview, when I listened to the court, when I listened to the broadcast from the attorney after, that there were a number of things mentioned. First, if you're looking for this premeditated portion, I think they've laid out that foundation for that. But there's also a charge specific to their state that talks about targeting. I'm intentionally targeting this victim. And so not only are they going at the premeditated portion, they're also hinting at the targeting aspect where they talked about the hate that he believed that Charlie Kirk was placing in the community. And because of that, that was his rationale for wanting to kill him. So that's what he communicated with his parents. That was what he communicated a number of times with his roommate / boyfriend. And so those are the things that I think they'll use for both of those elements of the crime, the one being the premeditated for the first degree, the second being with that targeting.
Khalif, obviously they want to make a strong case against Robinson here. Want to go to your level of expertise here. You are a criminal defense attorney. You handle high-profile cases. What would you be looking for in terms of the way maybe evidence was collected in this case to start building a mounting defense, against the state?
Yeah, I mean, how do I build a defense, right? And this is a lot of evidence right now that they're dumping out in real time. And so the first thing I do is, as they mentioned in the hearing, I'll wait to get the discovery. I wouldn't rush to judgment. I wouldn't go off of like sound bites that folks are making at press conferences. I'd wait till they dump the discovery on me there in the district attorney's office and let me see all the information they have, while at the same time having my own investigator investigating the process. There were a number of things that jump off the page to me when you're looking at the evidence that was presented so far. First of all, the DA talked about his father and mother recognizing his photo, right? But then the dad saying, hey, I gave him a shotgun as a gift. And he asked him, send me a picture of the shotgun. The son doesn't respond. Those are the types of things where, okay, we've identified a shooter, we've identified a weapon, and now we still have the weapon fingerprints. There's a number of physical evidence, but there's things corroborating. And so I mention this all the time. Once an incident occurs, law enforcement is going to work backwards. So they found the gun. Now they're finding who owns it. And now they're putting, into his hands and trying to weed out, well, who else was involved? Were the parents involved? Were the friends involved? Were the roommate involved? And now you can start to see, based on the information they have, he seems like he was acting alone and that this is the information that we have so far. But to the defense, it'll be hard to build it until you have all of that discovery. And then you start doing a couple of things. Now am I defending life? Right. Or am I defending, they're seeking the death penalty. So am I defending his life and attempting to avoid him getting the death penalty? And some of those strategies are a plea. If you're looking at probably the best analogous to this is the Dr. King shooting. James Earl Ray, when he shot him, he was brought back, extradited from London, brought back here, and instantly pled to 99-year conviction as opposed to the death penalty that he ultimately would have received. So that was lawyering on his part, but then you also need a prosecutor's office that's willing to accept a plea like that. In this scenario, I doubt that would occur. But in that MLK scenario, that was lawyering on his part of saying, this is probably not a case that we can win. Right. But can we save your life and ensure that you don't get, executed? This is a plea that we'd be willing to try to go down.
Going off that right there, saying it's a case they probably can't win, looking at the evidence that we've already seen, there's more that's going to come out, I'm sure, before they go to trial. This seems like an open and shut case. Is there such thing in the legal world as an open and shut case?
No, I mean, again, that's why I say I'd wait till they get the discovery. I mean, I not only would I have a fact investigator, right, that's out there looking at the facts, looking at all the information, information that they've given me, all the stuff that's over with Discovery, I'd also have something called a mitigation specialist. I want someone to look at his history, look at his past. Does he have a history of mental abuse? Does he have a sexual abuse? Does he have anything in the past that has shaped and molded who he is? So now I can mitigate this down to something where, does he even have capacity to stand trial? Is he outside of his mind? There are a number of ways that you can go, and so I'm bringing in that mitigation specialist that then may trigger me to get a forensic evaluation. So it's not open and shut in terms of conviction. It's just, it's definitely overwhelming evidence. It's a lot of information that they put out there, and you normally wouldn't see that. But what I will say is, it's very quick to the death penalty portion. Typically, you see an individual be charged with murder, and then there will be a determination later down the road of, yeah, we're going to seek the death penalty. This was a very quick decision, and it was a little bit of based on political and based on hate. And I think they came with those two things as to their rationale.
Yeah, the crossroads right there. Again, our chief legal analyst, Charlie Kirk, weighing in on that for us. Also going to have him join us later on to talk about what we've heard from Marco Rubio and what could happen to visa holders here who are celebrating Charlie Kirk's death. Khalif, thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.